the judges of the Court of Appeals, and His Excellency, the Governor of New York. The Laud Day ceremony will now begin. Please stand for the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave for the land of the free and the home of the brave.
It's true. The governor was disappointed that I didn't sing the national anthem myself. But Michelle comes from the Appellate Division First Department. And so I have a special interest in keeping her here up in Albany so she can sing for us all the time, just like she did in the First Department. But welcome to Laud Day 2009. What a delight it is to preside over my first Laud Day as Chief Judge of the Court of Appeals with the Governor of the State of New York, David Paterson, Solicitor General Barbara Underwood, representing Attorney General Cuomo, and my wonderful colleagues on the court, who I want to take just a moment to recognize, in seniority order, of course, Judge Carmen Saparik, Judge Victoria Graffio, Judge Susan Reed, Judge Bob Smith, Judge Eugene Piggott, and Judge Theodore Jones. They have all been warm and welcoming to me, and true to their word, they have kept the hazing to an acceptable minimum. Thank you. And we are also especially grateful and honored as a court to have Governor Paterson and Solicitor General Underwood here with us today, and you will be hearing from both of them shortly, along with the President of the State Bar, Bernice Lieber, who will come to us via modern technology videotape. I don't know how modern videotape is anymore, but we will see her on video. I also want to take a moment to acknowledge the special presence of some guests today, starting with former Chief Judge Saul Wackler and Associate Judge Joseph W. Bellicosa. Welcome home to both of you. I also want to introduce you, my dear friends and colleagues on the Administrative Board of the Courts, Presiding Justices A. Gail Prudenti and Anthony Cardona. And I don't see Judge Gonzalez. Did he make it? He was too busy, as he's celebrating with the governor in the Bronx. And we're also missing, of course, Hank Scudder from the 4th Department. But welcome, PJ. It's a delight to see you. I think we have Steve Banks, the Attorney-in-Chief of the Legal Aid Society. Steve, there he is. Peter Cannon, the counsel to the governor, is right there in the front row. Is Victor Kovner make it from the Fund for Modern Courts? Was supposed to be here. You look just like Victor Kovner. I don't know why I mistake you, you know. A lot handsomer than he is. And Assemblyman Lentil and Assemblyman Farrell, or I don't know if they're around. Not a legislative day, but we're so glad to have all of you here, so many of you. This year's Law Day theme focuses on the bicentennial of Abraham Lincoln's birth and on his influential legacy, a legacy that remains very much alive today in our continuous search for freedom, equality, and opportunity. Lincoln's legacy certainly lives on in the work of the judiciary. We are the ultimate arbiters of society's disputes and play a central role each and every day in providing justice to all of our citizens. While I will be giving my own Law Day remarks after the Governor and the Solicitor General, I could not let this day pass without noting that this is the 11th consecutive year in which New York's judges have not received a salary adjustment of any kind. But what I am so pleased to say on this Law Day is that the professionalism and commitment of the judges of the unified court system have never faltered, not for a single minute. Despite this patently unfair situation by any objective standard, they continue to do a magnificent job each and every day of serving the public and making the difficult, often gut-wrenching decisions that directly affect the lives and well-being of litigants, families, businesses, and communities all over our state. We are fortunate indeed on this Law Day to know that New York has absolutely the best judges in the entire country. I think they deserve a round of applause. And now it is my pleasure to introduce to you our first speaker. He is someone who understands firsthand what it is to govern during a crisis as he continues to steer our state through one of the worst economic downturns in memory. From my perspective as Chief Judge, I can tell you that when it comes to issues affecting the judiciary, Governor Paterson is incredibly knowledgeable, accessible, interested, and totally supportive. He has acted swiftly to fill numerous vacancies in the trial and appellate courts around the state, appointing a number of truly outstanding jurists. Although I concede some possible bias on this particular point, he has been a delight for the judiciary to work with, and we look forward to continuing to work with him to address the great challenges facing the unified court system and the justice system in this state. So it is my great honor and pleasure to introduce to you our terrific Governor, David A. Paterson.
Thank you, Judge Littman, for that very kind introduction and for confirming a belief that I held. Yesterday, I attended the swearing in of the new presiding judge in the First Department, Luis Gonzalez, and they read a letter from Judge Littman, who was in session in Albany and was unable to attend. And he writes, "This is a spectacular appointment." And I was wondering if he was referring to the appointment of Judge Gonzalez or his own just a couple of months ago. And now that he's confirmed it, I'm glad that we're on the same page. But Judge Littman, who I observed so often as the administrative judge, and with his great ability to see the issues and also the purpose, thank you for presiding over this first Law Day, and to all the other members of the Court of Appeals and all the members of the judiciary, and to Barbara Underwood, the Solicitor General, who is taking the place of the Attorney General, who was called away and is unable to join us this morning. Before I begin my presentation, so that I can leave here with clear conscience and no injuries, I also believe that the judges who have suffered for 11 years do deserve a pay raise. And we certainly hope, as we ferret through this downturn in the economy that has caused many of us to have to reassess some of the decisions that we would like to make, that we can escape from this crisis as soon as possible and move into a period where people are aptly compensated. Unfortunately, the judges had not received fair compensation for 8 years before we started to have a downturn in the economy. And to all of you who are here today on May 1st, I would like to say that the reason of purpose, the reason of being for our celebration and continued pledge to Law Day, I believe, is to fulfill the dreams of those Americans, both the living and the dead, both men and women, who throughout the past 2.5 centuries have struggled unremittingly and courageously to build a democracy that would be founded on the principles of equity and liberty and justice. Those, I think, are the principles of Law Day. Those, I think, are the perimeters in which we discuss this subject, and I hope that we will never stray from them. For the type of experiment that our foreparents underwent over 2.5 centuries ago has proven to be the most successful democracy in the world, and though it is often imperfect, we as human beings are imperfect, but no nation has ever striven more to try to level the playing field and create equality for all of its citizens than the United States of America. And yet, in its founding Constitution, contained an article, Article 1, Section 2, Clause 3, which provided for the institution of slavery in this country, and for purposes of population counting, that those slaves would be assessed as 3/5 of a man. They weren't even gender correct in this litany of the first article. And this enabled the state of Virginia to have the same number of electoral votes as the state of Pennsylvania, even though it had 1/3 of its population at that time. And so, also included in the Constitution was Article 4, Section 2, Clause 3, the provision that allowed for the recovery of runaway slaves, one that has never actually been preempted from the Constitution, though in my copy it says in a scholarly way that this is probably no longer relevant after the passage of the 13th, 14th, and 15th Amendments. How comforting. But nonetheless, this article became really one of the most interesting and probably dialectic concepts in the Constitution for nearly its first years of existence. For the notion of slavery was originally described in the founding Declaration of Independence as the greatest woe to mankind, but because of a coalition of New England slave traders and Southern planters, that concept didn't make the final cut to the 1776 Declaration on July 4th of that year. And 11 years later, the view was inculcated more firmly in the founding Constitution. But this became probably the greatest dispute about the definition of law and its actual meaning for years to come. From the Louisiana Purchase in 1803 to the Missouri Compromise in 1820, which held that there would be slavery north of the 36th parallel what to do about this concept was foremost in the minds of some of America's greatest scholars. The same democracy that Montesquieu conceived, and that in many respects that Adams and Jefferson implemented, and that Madison and Ben Franklin advocated for, was hindered to a certain degree by the continued discussion of what to do about the thousands of slaves and then millions of slaves that existed on the lands of the new nation. Finally, in 1850, a compromise was struck where California was admitted to the Union as a free state, Texas as a slave state, Utah and New Mexico as neutral territories, and slavery was abolished in Washington, D.C. But all of this boiled over in the Kansas-Nebraska Act of 1854, in which for the binary admission of these two states, there was a concession about whether or not there would be slavery north of the 36th parallel. And so all of this was in the minds of the judges of the United States Supreme Court when they rendered a decision in the Dred Scott case in 1857, commonly held to be the case that sustained the concept of allowing slavery north of the 36th parallel, but that is a misnomer of history. That was resolved in the case of Strader versus Graham in 1852 and was only repeated and affirmed as the court rendered its verdict not on the basis of the Kansas-Nebraska Act, but on the simple doctrine that went back to Article 1, Section 2, Clause 3 of the Constitution, that if an individual was not considered to be a whole man or whole human being, he had no rights in a federal court, no other rights than any non-human would. And so this was the backdrop for the intervention of President Abraham Lincoln, born 1809, whose bicentennial birthday we celebrate this year, and who was in 1862 arguing with Congress that, as he put it, that the quiet of the distant past is not accurate to the stormy future. And what he was saying was that this issue of the inability to resolve this in one of the sections of one of the original article to the Constitution had in many respects contributed to other issues involving the Civil War. Finally, on September 22nd, 1862, Lincoln signed the Emancipation Proclamation and then had to sign it again in November to cover the territories that were not in statehood, allowing for the emancipation of the slaves. But the contention that I'm making here today is that the Dred Scott decision, although many people dread the Dred Scott decision, the reality is that by law, it was the correct decision. It followed the law as the Constitution was written at that time, as expressed through Judge Roger B. Taney in his decision. Though two judges dissented on issues relating to human rights, they were outside of the perimeters of where the Constitution allowed at that particular time. And even the Emancipation Proclamation theoretically could have been questioned for its legitimacy. Only a bloody civil war and the passage of the 13th, 14th, and 15th Amendments allowed us the opportunity to finally have a law that provided for this type of equality for now the people now known as African Americans. But we had to pass another amendment some 50 years later to give women the right to vote. And we had to pass other amendments and statutes and rulings in order to bring our Constitution and original Declaration of Independence into the boundaries of what we would now consider to be the fairest and most equitable system that exists in the world. And so as we look at the evolution of law over this period, we have to understand that though it is the duty of our judges to follow the law explicitly and to be in construction with our Constitution, that the Constitution is not as an inanimate object, but more like a tree which grows and whose branches continue to yield liberty and justice to those who live within its jurisdiction. And so this is what brings us to Law Day, the understanding that our role as legislators and even as in the executive branch and in the judiciary are to follow the laws. not to reinterpret them, but to follow them. But where we feel that the laws are not adequate for current times, it is our desire to try and change those laws. And it is through that inertia inherent that we have such a great court system as we have here in the state of New York, the great judges of our Court of Appeals, and a system that has proven to be beneficial for us throughout the couple of hundred years that New York State has been founded. And so this is the great history that we live in and that we discuss on Law Day in the hallowed halls of this complex. And this is what we try to seek when we appoint judges to the highest positions in our state. We have a commission on judicial nomination that does such. And I have an appointment to that commission, and I'd like to announce this morning that I'd like to ask the former Chief Judge of the Court of Appeals, Judith Kaye, if she would accept that nomination, and she has, to serve on the Commission for Judicial Nomination. She will bring added integrity to that process, and where in the past perhaps we might have been able to at least consider a wider range of candidates who may have ability that might be commensurate with what we're looking for on our Court of Appeals, we know that the newest member of the Commission will help us find them. She is ready to serve, and we happily await her appointment. And to all of you who would want to spend this Law Day with us, we recognize that our system and our law, while it is binding, is also imperfect. And we go back to our relatively different tasks, but all coming together, as Montesquieu advised us years ago, in a democracy that often frustrates us, but has a balance, and gives to each partner within our troika of justice in the state certain opportunities and certain roles. And though they often conflict and it may take longer for us to dispense justice, we are able to do it in the most positive way because there has been adequate collaboration between the branches of justice. And so it is in that vein that we recognize that our responsibilities are still just as strong as it was for our ancestors 250 years ago. We have to fight and struggle for those changes we feel are necessary. At the same time, we have to understand what is due on to us through the laws that guide us and obey them to our best ability. It is in that spirit that I thank all of you for attending Law Day, and thank you for joining us in this great celebration. Thank you.
Thank you, Governor, for those wonderful remarks. Before I introduce the next speaker, I would note that the Mayor of Albany, Jerry Jennings, is here with us today, and as always, we are honored by your presence. Our next speaker is our very, very accomplished Solicitor General, Barbara Underwood, who, as you know, has just a spectacular resume, having served as counsel to the United States Attorney for the Eastern District of New York and as Chief Assistant U.S. Attorney for the Eastern District. In 2001, she served as Acting Solicitor General of the United States, and from 1998 to 2001 was Principal Deputy Solicitor General. Among other notable positions, Solicitor General Underwood was also a law clerk to U.S. Supreme Court Justice Thurgood Marshall. So she has a pretty impressive resume and is a pretty impressive person. Love to introduce Solicitor General Barbara Underwood.
Chief Judge Littman, Governor Patterson, Associate Justices of the Judges of the Court of Appeals, State Bar President Lieber, Chief Administrative Judge Pfau, and distinguished members of the bench and bar. First, I need to say that Attorney General Andrew Cuomo is unable to be here today because of an emergency that came up unexpectedly in New York City. I bring his apologies and good wishes. For myself, I'm honored to be participating in these Law Day ceremonies in this great courthouse. This is truly one of the finest appellate courts in the nation. The cases are important, the judges are outstanding, they give the lawyers and their cases the attention they deserve, and the courtroom, of course, is breathtaking. The richness of this court's history, its stature as a beacon of justice and a leader among state high courts, is a constant source of inspiration. I'm especially happy to join today's Law Day celebration with our new Chief Judge, Jonathan Lippman. We're fortunate that our courts will have the benefit of his vast experience and energy during these very challenging times. And I thank him for his kind introduction and wish him great success as he begins his tenure as Chief Judge. As we know, this year marks the bicentennial of the birth of our 16th President, Abraham Lincoln. The last time Lincoln came to Albany was on February 18, 1861, on his way to his inauguration in Washington. He arrived by train, his car pulled by a locomotive bearing the name of Erastus Corning, Jr., the great-grandfather of the man who would later be mayor of this city for 40 years. He gave a speech to a joint session of the legislature and then proceeded to Washington, where he built a record that stands as an inspiration to us all. He left a literary legacy of speeches and writings that the world will long cherish, and more magnificent than his words were his deeds. He saved the Union, and he gave new meaning to the freedom that has always been this nation's ideal. By signing the Emancipation Proclamation and campaigning for the 13th Amendment, he brought more liberty to more people than anyone else in American history. With the stroke of a pen, he freed more than 3 million enslaved African Americans, taking a long overdue step toward realizing the promise of our founders that we hold these truths to be self-evident, that all men are created equal. Equality for women was still in the future, and we're still working out in our courts the full meaning of the Civil War amendments that codified his work, their promise of due process and equal protection, and the modern meaning of the promise we make every time we take the Pledge of Allegiance, the promise of liberty and justice for all. But in 1864, Lincoln was deeply concerned that liberty had to include justice, and liberty and justice were for all. In a speech he gave at a state fair in April 1864, he said, "The world has never had a good definition of the word liberty, and the American people need one. We all declare for liberty, but we do not all mean the same thing. For some," he said, "liberty means that people may do as they please with themselves and the product of their own labor, while for others it means they may do as they please with others and the product of the labor of others. Here," said Lincoln, "are two different and incompatible things called by the same name, liberty." He illustrated his point with a parable. He talked about the shepherd who drives the wolf from the sheep's throat. The sheep thanks the shepherd as his liberator, while the wolf denounces him as the destroyer of liberty. Plainly, the sheep and the wolf are not agreed upon a definition of the word liberty, said Lincoln. Of course, that same difference separated the states during the Civil War. Both sides professed to love liberty, but the Wolf's Dictionary was rejected, and the process of ending slavery began. Every successive generation in law and politics confronts anew the dilemma articulated by Lincoln. We all claim commitment to freedom, equality, and justice, but we do not agree about the meaning of those terms. That is why we lawyers bring cases to this court, to tell us the answers. Right now, a dispute over the meaning of liberty appears in debates about how to address the current economic crisis. Some fear we may react to the collapse of the markets with too much regulation, and that over-regulation of the markets will destroy liberty. Others believe the collapse occurred because of a failure of regulation, and that to preserve free markets, government must regulate them. I don't know what Lincoln would have said about modern markets and the modern administrative state. We know, however, that he took some steps that resemble the stimulus approach to economic difficulties. He promoted a great many projects that used to be called internal improvements, and we now call investing in the infrastructure, the technique that creates both jobs and public services. In Lincoln's day, it was railroads and canals. Today, it's roads, bridges, public transportation. Lincoln signed the law creating the land-grant colleges that were the predecessors of our state colleges and universities. And he signed the National Bank Act, which paved the way for a new kind of federally chartered bank. I can't resist pointing out that while he was determined to protect the Union and its national banks from destruction by the states, he surely did not intend to bar the states from enforcing their anti-discrimination laws against national banks, as I hope I convinced the U.S. Supreme Court just a few days ago. Lincoln's idea of liberty was not just the right to be free from government interference, but the right to pursue happiness. That kind of liberty requires economic security. If people are without work or food or dignity, they are not free. Our state constitution, more than the federal constitution, expressly recognizes that. It expressly obligates government to provide for the aid, care, and support of the needy, and makes a meaningful public school education a constitutional right. Once again, we can disagree, and often do, about exactly what those provisions mean, and bring our disagreements to this court. But our basic constitutional commitment to social and economic rights, as well as civil and political rights, defines who we are and what we value. Our state's vision of the good society has long embraced the entire family of New York, and indeed the nation. Lincoln told New York on the brink of the Civil War that the nation needed the united support of the great empire state. New Yorkers responded with more men and more supplies than any other state in the fight for union and liberty. And so, almost a century and a half after Lincoln last spoke in Albany, we know some things about where he would stand on the great issues of our time. We know he would stand with the people. He would stand with people of all races, colors, and religions. I hope he would also stand with men and women, young and old, rich and poor, gay and straight. For in the end, Lincoln's most enduring lesson is that ours is not only a government of laws, but also a government of the people, by the people, and for the people. And that is a lesson we all do well to remember on Law Day and every day. Thank you.
We in the courts and the legal profession have special reason on Law Day to celebrate the bicentennial of Abraham Lincoln's birth. Lincoln's background as a lawyer greatly influenced his views on justice and liberty. His reverence for the Declaration of Independence and the United States Constitution reinforced his already deep opposition to what he called the monstrous injustice of slavery, and gave him the courage and conviction to prosecute the painful and bloody Civil War that kept our nation together and put an end to the greatest injustice of his day. I believe Lincoln's legacy inspires us to continue opposing injustice in our times and righting the wrongs as we see them. Today, all of us in the justice community, with total unanimity, see no greater wrong than the conviction of an innocent person. It was just 20 years ago that DNA testing was used for the first time to exonerate a wrongfully convicted person. There have been 235 documented DNA exonerations in the United States since then, 24 of them in New York alone, not to mention the scores of exonerations based on traditional, non-DNA evidence. Each one of these cases represents a tragic miscarriage of justice, a grave failure of our criminal justice system, and a serious threat to public safety. But while every wrongful conviction is a tragedy, it is also a unique and valuable opportunity to identify and understand what went wrong with the criminal justice process. What was it that misled police and prosecutors? What was it that caused juries and courts to find an innocent person guilty beyond a reasonable doubt? What can we learn from these tragic mistakes to make sure they don't happen again? What patterns keep repeating? What flaws in the system must be remedied? As investigators, prosecutors, defenders, judges, and policymakers, what reforms and protocols can we adopt to avoid the risk of wrongful convictions? We have had a patchwork of public and private efforts to address these questions in states around the country with very mixed results. Pioneers like Peter Neufeld and Barry Scheck of Cardozo Law School have done extraordinary work to advance this issue nationally. And here in New York, the State Bar Association, with Judge Barry Kamens as chair and Professor Will Hellerstein as a member, both of whom are here today, just recently issued an important report addressing wrongful convictions. And Assemblyman Gianaris has long sponsored a bill here in New York in this regard. I believe it appropriate on Law Day to announce that the judiciary in New York is taking these efforts one step further by creating the Justice Task Force, a permanent, independent group of prosecutors, defense attorneys, judges, legislators and policymakers, police officials, scientists, and academics who will work together to isolate the factors that lead to wrongful convictions and recommend specific reforms not only to strengthen the accuracy and reliability of the criminal justice system, but also to improve public safety. In my role as head of the judicial branch of government, I am establishing the Justice Task Force for two reasons. First, because the criminal justice process, just like the human beings who make it work, will forever be imperfect. And second, because the courts occupy the central role in our justice system. When there is a miscarriage of justice, we, in so many ways, bear the ultimate responsibility, both in perception and reality, because it is within the framework of the judicial process and with our imprimatur and through our rulings that questions of guilt and innocence are determined. Judges carry the heavy burden of ensuring a fair, if not a perfect, trial. Therefore, we have an obligation to lead the way in making sure that the justice system is as even-handed and accurate in its judgments as humanly possible. We do not have the luxury of being wrong when it comes to the grave issue of guilt or innocence. The lives, well-being, and the very liberty of human beings and their families is at stake, as well as the paramount issue of public safety. It is a cause that unites us all. No one, not law enforcement, not defenders, not judges, not the public, ever want to see an innocent person punished for a crime that he or she did not commit. When that happens, we all fail. And the consequences of a wrongful conviction are indeed profound and affect us in so many ways. when law enforcement and the courts are focused on the wrong person. The public is at risk as the guilty party remains free to commit additional crimes that could have been prevented. When someone is exonerated, the victims and their families must relive that terrible nightmare once again, years after they had come to believe that justice was done and the guilty party safely locked away. And of course, the public's confidence in the justice system, and the courts in particular, cannot help but be seriously shaken. It is my great pleasure today to announce the two co-chairs of the task force. First, the Honorable Theodore Jones, my distinguished Court of Appeals colleague, and in his prior life, a highly experienced criminal defense attorney and trial court judge. Joining him is District Attorney Janet DeFiore of Westchester County, one of the outstanding prosecutors in our state and a former justice of the state Supreme Court. I am grateful to both of them for accepting my invitation to lead this critical effort, and I truly believe that with the two of them at the helm, the Justice Task Force will be the most significant effort of its kind in the country, both in terms of its unique approach as an ongoing entity and its potential to bring about meaningful, positive change in the criminal justice process for all New Yorkers. I am also particularly pleased that this effort will have the interbranch collaboration and cooperation that is essential to its success. In this regard, absolutely critical players, including Senator Eric Schneiderman, Chair of the Senate Codes Committee, Assemblyman Joseph Lenthal, Chair of the Assembly Codes Committee, and Denise O'Donnell, Commissioner of the New York State Division of Criminal Justice Services, have agreed to serve as members of the task force on behalf of the legislative and executive branches of state government. In no other state has the judicial branch of government, in conjunction with our partners in government, established a permanent body not only to conduct a comprehensive evaluation of wrongful convictions established by DNA or other evidence, but also to monitor these issues on an ongoing basis to gauge our success in implementing reforms designed to safeguard the very integrity of criminal convictions. I want to be clear about the mission of the Justice Task Force. It is not to investigate claims of innocence, but rather to carefully review every case in which there has been an exoneration. Nor is it to assign blame or point fingers, but rather to determine what went wrong in these cases by looking at court records, evaluating investigatory practices, consulting with experts, reviewing scientific research, holding hearings, issuing periodic reports and recommendations, and closely tracking the progress of any changes fostered in this area to ensure they are working as intended. The task force will pursue its work and mission without any preconceived agenda. Rather, it will be free to set its own agenda, to go wherever the facts and issues may lead it, and to recommend whatever measures it believes are in the best interest of the entire criminal justice system. Where the judiciary can implement the task force recommendations through our rulemaking and administrative powers, we will do so. And where the recommendations require legislation or action by other entities, we will vigorously urge their adoption by the appropriate bodies. I have asked the chairs to report back to me by December 1st of this year. New York has reason to be proud of its history in enacting the country's first post-conviction DNA testing statute. I have every confidence that the work of the Justice Task Force will once again put New York at the forefront of national efforts to prevent wrongful convictions, protect public safety, and strengthen the quality and reliability of our criminal justice system. The judiciary is fully committed to that end, and I look forward to the cooperation and support of the criminal justice community and our partners in government. Thank you all. Thank you. Our next speaker, as promised, on video, is our fabulous president of the State Bar Association, Bernice Lieber, who had a family obligation and was unable to be here today, but again, through the wonders of modern technology, Bernice Lieber.
Chief Judge Lippman, Governor Patterson, Attorney General Andrew Cuomo, and distinguished guests. Today, Law Day, we celebrate the 200th birthday of a man who lived to be only 57 years old. Lincoln's greatest legacy is to remind us, as lawyers and citizens, that the work is still unfinished, and the law remains a higher calling because it empowers us to fulfill the promise of America: life, liberty, and the pursuit of happiness. One of the best orators in our nation's history, Lincoln represented the conscience of America when he said in the Gettysburg Address, referring to those soldiers who had fallen, "It is for us, the living, rather to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced." As a lawyer, Lincoln and his partners handled over 5,000 cases. He rode the 8th Judicial Circuit, traveling with other lawyers and judges, and sharing not only a room, but often sleeping 4 in a day. For most of his working life, Lincoln toiled as a lawyer. He handled all kinds of cases, for all kinds of people and businesses. He believed in public service, and he served terms in the Illinois legislature and one in Congress. In 1838, 20 years before the famous Lincoln-Douglas debates, he spoke publicly about the unfinished work of those who fought for freedom in founding our country just 50 years earlier. Lincoln confirmed his belief in the importance of the rule of law. He feared what he saw as, quote, the increasing disregard for law, the growing disposition to substitute the wild and furious passions in lieu of the sober judgment of courts, and the worse than savage mob for the executive ministers of justice, unquote. Lincoln was, of course, referring to recent incidents of civil disorder, from burning churches, ravaging provision stores, throwing printing presses into rivers, shooting editors, and hanging gamblers in Mississippi, and blacks suspected of conspiring to raise an insurrection. It is fitting then, in this year, 2009, that we as lawyers also remember those who fought not so long ago in our recent history to respect the rule of law and the rights of those less fortunate than ourselves. And they include lawyers who fought for the voting rights of African Americans, lawyers who brought legal challenges in our courthouses over segregation in our schools, and lawyers who defended the rights of others in order to ensure that they too would have an equal footing in America. Lawyers like Abraham Lincoln have been defending the rights of their clients, and to this day, we continue to fulfill Lincoln's profound mission of public service, unpaid, pro bono legal service. The greatness in being a lawyer today is then to continue doing the public good, the work that Lincoln referred to in 1863. So, whether it is representing detainees at Guantanamo Bay or homeowners who face foreclosure, whether it is representing those who were wrongfully convicted or coming to the aid of those who lost loved ones in 9/11, and more recently, those who lost loved ones in the crash of Flight 3407 over Buffalo. lawyers throughout New York who faithfully serve clients for no charge remain the quiet heroes of our profession. Let us remember then, on this law day, that the greatness of Lincoln lives on in the work that is yet incomplete, in the lives of people who continue to need our representation. Lincoln lives on in each of us, and for our continuing to do the public good. Thank you.
Before I give the program for the award ceremony to our wonderful Chief Administrative Judge, Ann Pfau, who I have had the pleasure of working with for the last 19 years, and Fern Fisher, who isn't even that old, so, the Deputy Chief Administrative Judge for the courts in New York City. I do want to note in the audience is Jan Plumador, the Deputy Chief Administrative Judge for the courts outside New York City, who has done such a terrific job for so many years and will be stepping down soon from that role. And I want to thank him for all of his... And I'd be remiss not to mention Judy Kluger and Juanita Newton, Judge Judy Kluger and Judge Juanita Newton, who have been stalwarts, but they're continuing in their roles, in their relatively new roles. So thank you both. It's now my pleasure to turn the program, the awards part of the program, over to Judge Pfau.
Thank you, except I have a little problem. Okay, we just didn't have that conversation before, sorry. Thank you, Judge Lippman. My part of today's program, my really delightful part of today's program, is the awards portion. First, I'm going to give out the 2009 Merit Performance Awards, one of which is being awarded posthumously to outstanding court employees. Every year, we use this wonderful occasion at the court to honor the men and women who support the judges and provide great service to litigants and their communities. Following the Merit Performance Awards, Deputy Chief Administrative Judge Fern Fisher will present the David A. Garfinkel Essay Prize to two outstanding students. This year's Merit Performance Awards recognize four of our own: Ava Anderson, Craig Snyder, Sarah Luck, and posthumously, Albert Gelb. They represent the very best among us, and I would like to tell you briefly about each of them as they come up to receive their award. The first is Ava Anderson. Ms. Anderson is a court assistant in the Mount Vernon City Court. City courts are very busy places with large caseloads, and the Mount Vernon City Court is among the busiest. Not everyone enjoys working in this environment, but Ava thrives on it. She does it all with a smile and great professionalism, and has earned the accolades of everyone who touches the court, the judiciary, the bar, and the public. So, Ms. Anderson, on behalf of the court system, it is our great pleasure to give you the Merit Performance Award for superior work performance. Thank you. Thank you. Craig Snyder. Craig Snyder is a principal court attorney in the Steuben County Courts who has devoted himself to the community with remarkable dedication. He directs a summer children's program with goals that inspire us all, goals such as honesty, integrity, and tolerance. Craig and his wife continue to work with students year-round, hosting clubs and helping to develop better citizens. So I'm so pleased to recognize Craig's great service with the 2009 Merit Performance Award for Outstanding Educational Efforts. Sarah Luck. The generosity of the men and women who work in the judiciary is boundless, as Sarah Luck demonstrates every day. Sarah, who is the resource coordinator in the Fulton County Drug Treatment Court, cares deeply about her community and never stops giving. She serves those in need, improves local neighborhoods, and looks out for drug court participants. Ms. Luck is someone who gets results when results matter and continually improves the lives of those around her. For all that she does, I am delighted that we are here together to recognize her with a 2009 Merit Performance Award for Community Service and Humanitarian Pursuits. The last award is the posthumous award, and we're joined today by the members of the family of Officer Albert Gelb, and Miss Emily Gelb is going to come up and accept the award. Our officers are remarkable professionals, and Officer Albert Gelb, who was killed because of his selflessness and heroism, was the best of our best. Officer Gelb, while off duty, came to the assistance of a waitress, and in so doing, paid the ultimate sacrifice, killed because he insisted on doing the right thing. He is a hero, he is our hero, a highly decorated court officer who would not be intimidated in his service to others and fulfillment of his code of honor. Officer Gelb's sacrifice continues to serve as a shining example to us all so many years later, and we are grateful to have the opportunity to honor him with the 2009 Merit Performance Award for Heroism. And now it gives me great pleasure to turn the program over to Deputy Chief Administrative Judge Fisher.
Good afternoon to our great Chief Judge on the occasion of his first Law Day and many more to come, our fantastic governor of this wonderful state, Court of Appeals, Solicitor General, and guests. It is my honor to be asked to present the next award to the bright lights of the future who will ensure that the rule of law will endure. This award comes from the Historical Society of the Courts of the State of New York, which was launched in 2003 by our retired and beloved Chief Judge Judith S. Kaye. It has the mission of preserving the legal and judicial history of the State of New York, and it seeks to foster scholarly understanding and public appreciation of the rich legacy of the New York courts, the legal profession, and their contributions to the state and the nation. Due to the generous funding of Gloria and Barry Garfinkel, the Society launched the David A. Garfinkel Essay Contest in 2008. The contest is offered to community college students in the CUNY and SUNY systems. This year, 32 essays were submitted from community colleges across the state. The essays were reviewed by a team of attorneys in the Court of Appeals, and the winners, the first and second place winners, were selected after the strict scrutiny of Chief Judge Judith S. Kaye. Now, before I move on to today's winners, I want to talk just a bit about last year's winner of the 2008 essay contest, Elijah Fagan Solis. And this is just a bit of an update. It's always nice to know what's happening with our young people. And I believe he's here today. Is he here today? Yes. Mr. Solis Fagan Solis, graduated from Hudson Valley Community College with a wonderful GPA of 4.0. You can't get better than that. He is now attending Sage College of Albany and is majoring in law and society, and he's interning at the state legislature. So he continues to do impressive work. Thank you so much for continuing your good work and for being here today. All right, today's winners. These winners won after writing an essay on a very impressive topic, the New Netherlands legal system and the law of 21st century New York. And how many of us could write on that topic? And I'd like the two winners to come up, Courtney Malowich and Dewar Jamal. Courtney, our second place winner, is a paralegal major at Schenectady County Community College. She carries an impressive 3.6 GPA and is currently on the Dean's List. She graduated with honors from Ballston Spa High School, where she was also a scholar athlete. She has two siblings, Christopher and Corinne, and she currently works at TGIF Friday, so she goes to school and she works as well. After graduating from community college, she plans to continue her education, focusing on English, which is her favorite subject. No wonder she's our second place winner. Eventually, Courtney wants to graduate from law school and become a successful attorney, and she wants to continue to help people, which gives her the greatest satisfaction. Our winners are receiving a scholarship and a memento for the Court of Appeals. I'd like Courtney's family to stand and be acknowledged. Congratulate her family and those that support her for helping her get this far to date. Courtney, congratulations. Thank you. Let's congratulate her. Our first place winner, who impressed Judge Kaye so much, Dewar Jamal. Dewar emigrated to New York with his family from India when he was 4 years of age. He attended public school in New York City, graduating from Hillcrest High School. He has a deep attachment to the history of New York, since this is where his family chose to call home when coming to the United States. After graduating from high school, he moved to Atlanta, Georgia for 8 years to pursue a career in retail sales. The lure of New York City and all it has to offer, especially in the area of his education, led him back to Queensborough Community College to pursue a degree in business administration. He currently also has a 3.6 GPA and plans to transfer to Baruch College after graduating from Queensborough in December of 2009. Mr. Jamal would like to pursue a career in law after graduating from Baruch. His essay in its entirety is printed and is with your program. I really strongly suggest that you write it. He's an impressive young man. Our first place winner, Dewar Jamal. Now, I understand that Mr. Jamal is engaged to be married in October of 2009, and his fiancée is here, Jennifer Ahmed, and perhaps some of his family. Please stand and be acknowledged for the support that you've given him thus far. Let's acknowledge Mr. Jamal again. We look forward to hearing the update on these two individuals next year, and I'm sure they'll do just fine. Thank you so much.
The last part of our program is a special award that's going to be given today, and I'd ask Judge Lou Douglas to come up. The Franklin H. Williams Judicial Commission on Minorities recently celebrated its 20th anniversary. In that time, the commission, first established really by Judge Wackler, has become a national model for how state court systems can promote equal justice and address issues of concern to minority employees and litigants. For 17 of its 20 years, the commission was chaired by one extraordinary person, the Honorable Lewis L. Douglas. His wisdom, leadership skills, and commitment made him a driving force behind some very important accomplishments, especially much improved minority representation in the non-judicial workforce. Under his leadership, the Commission contributed to the advancements made in so many other key areas, including jury representativeness, community outreach, access to justice, and addressing the disproportionate number of minorities in our criminal and family courts. Judge Douglas is with us today as a very, very special guest of the Court of Appeals, and it is my great privilege to present to him a special Lifetime Achievement Award on Law Day 2009. Judge Douglas.
This afternoon gives me a special opportunity to thank someone who probably doesn't remember what he did for me. But it happens that Governor Patterson put my name in nomination maybe 20 years for the Court of Claims. I doubt that he even remembers. But you know, in New York City, particularly in the African-American community, people will ask you, do you know the governor? The standard answer is, he's my closest friend. And if you want to add credibility to it, you say, well, our kids went to daycare together. The truth is, I have not for 20 years been able to thank the governor for that nomination, and it gives me a chance to do that now. And I'm sure that Judge Bellicosa knows that we from St. John's like to brag about our St. John's alumni. So I want to make the point that I was appointed by Ed Koch along with Carmen Saparik in 1978. And at another St. John's graduate who was my chief strategist when I ran for election, Ted Jones. So we St. John's folks want to stick together. I certainly want to thank Jonathan for arranging this award. He's been the strongest supporter of the goals of the Commission. Not only publicly, but he's been the strongest supporter even in the private conversations where things really get done. And I want to thank all of the judges in the state. I've been a judge for a long time, and I have never met a judge who did not want to be desperately fair. So that we should point out that the issue we face on diversity today is very different than what we were talking about in 1950. Today, that issue competes with a lot of other important issues. How to get more computers, administrative issues, how to get judges raises. So what the Commission really does, it's a place to organize that concern. And we ought not read its presence as evidence that there is some simmering, unsolved problem in New York State. We have recognized the need to generate and direct the importance of that issue of diversity. And finally, I would, this is like a family affair to me. I'd like to introduce my children, but my cousin is at the head table, and since this is a high IQ group, you probably have figured out my cousin. my cousin is first. And I want to introduce my children, who themselves are involved in this whole effort to achieve greater fairness in our profession. My son worked for Senator Dunn in the Civil Rights Division. He was a prosecutor for a while, and then someone pointed out to him that he was facing massive tuition bills. So he is now a partner with Shook, Bodie, and Hardy in Washington. Well, there's 1,000 lawyers, and they do whatever big law firms do. And my daughter continues the family business. She's a partner in Moses and Singer and was recently appointed chairman of the Diversity Committee of the Estates and Trust Department of the State Bar. So I acknowledge their presence and love. And finally, my wife Doris has health problems. She's not here. But those of us who know us know that Doris is the center of our family. So I thank you all again, and I'm delighted to be here and receive this award.
On behalf of the judges of the Court of Appeals, our former colleagues, Chief Judge Wackler and Judge Bellicosa, we are so pleased that all of you joined us today on Law Day, and we wish you a wonderful day. We're so proud to have the Governor here and the Solicitor General. Thank you so much, and we'll see you next year. Thank you.